Thank you, Director Vidal, for joining us this morning and starting us off. I think she highlighted a couple of critical elements of today that we're going to get through, including the ease of access of utilizing resources that we're going to share with you, as well as the insights that you're going to hear from speakers throughout the day. So as the director mentioned, the enforcement team, Holly and I are part of, which is in the Office of Policy and International Affairs. As she mentioned, we provide technical advice, analysis, and expertise on domestic and global intellectual property enforcement issues. So this includes coordinating with interagency partners, some of whom you'll hear from today, as well as working on trade policy abroad. But with that, I'll welcome Holly Lance, who's an attorney advisor on our team. She's going to discuss how trademark registrations level up your trademark enforcement.
Thank you, Amin. Good morning, everyone. As Amin mentioned, my name is Holly Lance, and I am an attorney advisor in the Office of Policy and International Affairs. I had conceived of this program a couple of years ago. I think we do a wonderful job. Trademark Customer Outreach has our quarterly trademark boot camp. Some of you participating today might have participated in that great series. And I feel like we get the trademark registration and then we say, send you out into the world. So my hope with this program today is to know that once you have your trademark registration, that in some ways is just the beginning of your journey as a trademark owner. And we do not want you to feel like you are alone being sent into the world. So I wanted to start today first by congratulating those of you who are new trademark registrants. It is not always an easy process. It can be a quite lengthy process and a complex process. So first, congratulations. And I also wanted to let you know about some of these new superpowers that you have as a federal trademark owner. So this first screen here is just going to summarize what I'm going to be speaking out about a little bit more in depth. So the first superpower that you have as a trademark owner is the power of deterrence. So what I mean by deterrence is the power to basically form a super shield, I guess, continuing this metaphor of superpowers around you. Now, you might have encountered this as you were filing or going through the trademark registration process, that you might have received what's called an office action, a notice from the U.S. Patent and Trademark Office that a search had been performed and that there was another trademark registration or a prior application filed that the office was concerned might be confusingly similar to the trademark that you applied for. So if you haven't encountered this before, know that now that your trademark has been registered, your trademark is now going to be part of that search process that trademark examiners perform. It was actually as soon as you filed your application. So when new folks are applying to register a trademark, if it is in fact confusingly similar to your trademark, and I realize that's a little bit squishy, we'll talk a little bit later today what confusingly similar means, then that trademark will be not allowed to proceed. It will in fact be, perhaps, will not allowed to register. So in addition, your trademark also appears on the Federal Register. Now, hopefully before you filed for your trademark application, you did perform some kind of search, and I will say that's the general recommendation. So when prospective applicants are searching for trademarks that are available, they will see your trademark. Again, started at the application stage, but now they know it's got that superpower, and they will be less likely to go forth with registering or applying to register that trademark. And also, once you have that R symbol, that can be somewhat of a deterrence for bad actors. They see that this is someone who cares enough to take the time to register their trademark. So if I were a counterfeiter or I'm a bad actor, I'm not going to take the guy who I know has a trademark registration because I know there's someone who's serious about their trademark. So simply having that registered R symbol next to your brand name or your product name can be enough to tell criminals, go move on to the next guy. And finally, we'll talk about this a little bit later, but there are some superpowers that you have against these bad actors. Now, also having a trademark hopefully you won't ever get into a situation where you have to go to court. And again, we'll speak with one of our speakers, John Fremming. We'll talk a little bit later about some of your options civilly before you have to go into a federal court to enforce your trademark. But in the event you are not able to work things out through a cease and desist letter or simply a nice communication to a infringer, and you do find yourself in federal court, you're going in there with a shield, or actually a sword, I should say. A sword, because there are several presumptions. These are sort of, it's a legal theory that allows a court to assume that a fact is true until such time as that there is a preponderance, greater weight of evidence that disproves the presumption. Okay, so what does that mean in everyday terms? Basically, there's going to be an assumption that your trademark is valid. That, yes, your trademark is indeed entitled to be registered, it is distinctive, it's ready to go. 2, that you are the owner of that trademark. And 3, that you have exclusive rights to use that trademark nationwide in association with the goods and services that that trademark registration covers. Now, that's not 100% sort of in the sense, in the eyes of the court, but unless the defendant can come in and show that it is more likely than not, 50%, 51% are more likely that you are not the owner, that your trademark is not valid, or that you don't have exclusive use, then the assumption is going to be that those facts are indeed true. So in other words, you're coming in, you're basically setting the scene, and you're saying, you don't think this is true, well, prove it. Because otherwise, the court's going to assume it's true just by having that federal trademark registration in hand. So this can be a big advantage. And again, sort of a deterrence, because who really wants to, now the burden is really going to be on that defendant. So they are going to be less likely to want to go into court unless they really have good evidence that one of these presumptions is not accurate. Now, this is a big deal. Coming into court is that you can also get statutory damages. So these are pre-established damages that are in the legislation that tells you what's available in counterfeiting cases. Now, both unregistered, so marks that you're just using common law marks, as well as federally registered trademarks can be infringed, but only registered trademarks can be counterfeited. And when we use the word counterfeited, we differentiate that from regular sort of garden variety infringement, in that it's the use of your trademark by another party where it's either identical or virtually indistinguishable from the registered trademark, and it's being used with the same goods and services, or again, virtually indistinguishable from those goods that are covered by your registration. So you can have a famous trademark, but if it's being used by somebody else with something completely different, then it's technically not a counterfeit. But if, let's say you're using, I know that Director Vidal mentioned Chanel. If using Chanel to sell bananas, not a counterfeit. Or toothbrushes, no. But because I doubt that they have trademarks on bananas. But I don't know, maybe. They have a lot of licensing deals. But if if someone is using the Chanel trademark or something with those interlocking C's on sunglasses, on handbags, or clothing, well, then we're talking counterfeit. Now, in those counterfeiting cases, if you are successful in court, you are entitled to what's called these statutory damages. So instead of having to prove to the court, well, this infringer, he made X number of dollars, or she made X number of dollars on these counterfeit handbags or sunglasses, you can simply ask the court for this category of damages, and the court has discretion to award between $1,000 and $200,000 per mark for each type of good or service sold, offered for sale, or distributed. So this can add up and be it can make it quite of a difference for this plaintiff who has had this infringement. And in fact, if the court finds that the defendant's actions were willful, but this was intentional infringement, and you can imagine in most of these counterfeiting cases, these are not defendants who just came up with the same great idea. They usually know what they're doing. They're not just, I thought it would be good to do an interlocking C, it's cute. In those cases, the court can increase the maximum damages to $2 million per counterfeit mark for each type of good or service sold. So again, we're not going to court as a money-making scheme. We're doing this because we've been ripped off, but you are going to get your sort of just desserts, or in fact, the defendant is going to get their just desserts for not following the law. So this is, again, can be a real deterrent against the bad actors, and can also be quite helpful if you do find yourself in the unfortunate situation of going to court. Now, the other thing, and this is sort of a more modern benefit, is the advantage that trademark owners have, federally registered trademark owners have with online e-commerce enforcement. Now, virtually all the large major social media and e-commerce platforms, they have online infringement notification forms, so that in the event that you do see a counterfeit or infringing product online, you can submit evidence of your trademark ownership, and then you can ask the website to take down those infringing listings. Now, enforcement is usually possible with unregistered, with common law trademarks, but the sites are going to be more likely to take action once they know you have that federal registration in hand, because of those presumptions we talked about before. And they don't necessarily want to be in the business of determining, well, is your trademark valid? Are you really the owner? If you have that federal registration in hand, again, that's walking in with the sword that gives that website certainty of your rights. And finally, some platforms have special registration platforms for registered trademark owners. So I'm thinking about the Amazon brand registry. eBay has their verified rights owners programs. So these are special programs that you can enroll in that make it easier to surveil listings and submit takedown requests. And the final advantage that I wanted to go over is the ability to record your trademark with Customs and Border Protection. Now, we're going to hear all about this in a minute with my colleague Suzanne, but recordation with U.S. Customs and Border Protection can really enhance customs officials' ability to detain and seize imported goods that violate trademarks. And this is an advantage that's really only available to federally registered trademarks. So if you have a common law trademark, you're not able to do that registration. As soon as your trademark is registered, you can then go and record it with CBP and have that enhanced protection. So I'm going to leave it there for now. I will, as a preview, let you know that CBP will be up next. So she'll be speaking all about that advantage. Thank you.
Okay, so the last question, and it touches on international issues, which is something the Office of Policy and International Affairs team works on. But in this case, an individual has a registered mark in the United States. They were at a trade show in a third country outside of the United States, and somebody that they were meeting at that trade show ends up registering their trademark in the third country. Does the owner of the trademark registration in the U.S. have any rights to take action abroad?
I hate to hear the kind of cases. The answer is no. So remember that concept of territoriality. The scope of your trademark rights is the bounds of the United States. So having a trademark here, great, very powerful in court, doesn't necessarily give you rights in that third country. Now, does that mean you're completely out of luck? It depends. Now, you would have to, of course, you'd want to consult someone who is familiar with the laws of that country. As I mentioned, most countries around the world are what we consider first to file countries. So if they kind of beat you to the punch and they start filing the trade, or if they start using and registering the trademark there, you might be out of luck. But in this case, we don't know. Are they just using the trademark there, or have they registered it? Because you could maybe register it first. Could there then be a battle over first use? Yes. But again, it's going to be a very fact dependent. But the general issue is that territoriality means your rights are extended to the U.S. only. That's why it's really important that if you are working with partners abroad, like at a trade show, you're going to want to sign some sort of contract about their use and just be very careful. Same with manufacturing. You want to be very careful that your IP stays with you.
Is there anything that the trademark team in OPIA wants to add to that, or are you comfortable with that?
Okay. Yes, I have we also have colleagues here. Just so folks know, the way OPIA is organized, we are on the enforcement team, Amin and I. We also have experts in trademarks, copyrights, patents, as well as a team dedicated to China. So if you have any of these kind of issues, you can certainly send it to us, and we'll make sure to send it over to the appropriate subject matter expert.